So, men's evil manners are written in brass, their virtues we write on water. It's always good to start a talk with a little Shakespeare. Helps convince people of your scholarship. But it's a great quote because it does capture the effect, the asymmetry, in a sense, of the criminal justice system and the way in which the consequences of a criminal conviction last long after the crime itself has been expunged and paid for. And that's, of course, the theme of today's presentations. In this first presentation, we're looking at the impact of prior convictions, the immediate impact of prior convictions, that is to say, at the sentencing hearing. And then we'll broaden it out from there. Rhys and I are doing a two-hander here. I'm going to introduce the topic a little bit more than I have done, and then he will take us into the guidelines, talk about the structure of the guidelines, the way the enhancements work. I'll come back to address the issue of justifications. Many people think, and many members of the public sort of take for granted, well, of course you're going to be more punitive towards recidivist offenders. It's strikingly obvious. But the justifications, I think, are a bit more complicated than that, and they lead in different directions. So we'll talk about the justifications, and then we'll come back to the impacts of these enhancements, because even if we can agree that punishments should increase to match the offender's prior convictions, and I think we can all agree on that basic proposition, the costs of this practice may be disproportionate, and so we need to understand both the costs and the benefits of prior record enhancements. And at the end of the session of our presentation, we'll put on the table for discussion some proposals, get your response to those proposals. But basically, we're asking questions about the way that prior record enhancements function across the US in the guidelines. And just on a comparative note, I should add that in other jurisdictions, England and Wales, mine, Canada and Australia and so on, it's a very different model, very discretionary. And one of the great advantages of the US guidelines is that you can see the practices. There's transparency, consistency and so on, and that permits the kinds of analyses that we'll be talking about today. Just a bit of background on prior convictions, criminal history at sentencing. This has been a relatively neglected area in criminal justice, and until about 10, 15 years ago, there was very little scholarship. The scholarship on the guidelines, whether Minnesota or other states, Pennsylvania, Washington, and so on, tended to overlook the issue of prior convictions. The focus was on other aspects, offense rankings and so forth. But more recently, there's been quite an accretion of scholarship on criminal history. And from the perspective of the Robina Institute, it culminated last year in this source book. And what we've done in the source book is we've taken a look at all the critical dimensions of a criminal history of prior record, and we've noted how the different guideline systems handle these dimensions. And so if you're interested in this sort of stuff, it's a very useful resource, we think. And there are copies available outside the room. And there's a couple of chapters on the subject, just to show you a little bit about the writing that's accumulated. So, what are the goals of our criminal history project? Well, we don't have any sort of agenda to do X, Y, or Z. Basically, what we're trying to do is, first of all, understand how prior record enhancements function, to explore the diversity of prior record enhancements across the states. And one of the points we will make, we will show in this presentation, is that there's huge variation, not just in the way that different guideline systems or states count prior convictions, but in the magnitude of impact. In some, Rhys will get into this in more detail, in some states there's a great deal of aggravation associated with prior convictions. They make a huge difference to the duration of custody, and others less so. So we want to explore that variation because it creates a natural experiment. And, you know, not everybody can be right. If Washington is one state that we will identify as having a pretty robust criminal history enhancement, more robust than in Minnesota. Well, are they onto something there? So we're interested in knowing whether different systems are more likely to reflect the accumulated evidence. So we're interested in an evidence-based analysis of the way these enhancements work. We want to explore the justifications in a little more detail. Most guidelines manuals simply assert that repeat offenders are more culpable and are higher risk, and that's the end of the story. But we think it's a little bit more complicated than that. And as I note here as well, we're looking at the costs and benefits. And the costs, of course, will be in a number of domains: prison space, prison costs, racial disproportionality, and so on. Now, Rhys is going to get into, we'll use Minnesota's grid as a good example or a good tool for discussion, because it's the oldest and about to mark, I suppose, about 40 years of existence. And Rhys is going to take us into this grid and discuss it, the effect of enhancements in Minnesota and other states. But I'll just make a couple of sort of preliminary warm-up comments. So the kinds of things we're looking at is, as you see, criminal history is one of the axes or dimensions. We can all agree that sentence severity should rise in response to the seriousness of the offense, but things get a little bit more complicated on the other axis. And we're asking questions like whether the enhancement should be higher or lower in particular zones of the grid. We're interested in the relationship between prior conviction and the offense of conviction, prior convictions and the offense of conviction. Is it the case that one is more important than another? On a retributive analysis, a just desserts kind of perspective, if the focus is on the offense of conviction, the crime of which the offender has just been convicted, then that should drive the sentence, and only latterly prior convictions. But in some cases, as you see in other jurisdictions, other states, the criminal history is driving the sentence to a much greater degree, and so we're asking questions about that. Minnesota lays out categories of criminal history based upon the points that the offender accumulates. So we might ask, well, if we have two offenders, one has a criminal history score of 2 and the other has a criminal history score of 4, and they're both convicted of the same offense, co-accused, is the offender in category 4 with 4 criminal history points, is he twice as blameworthy? Is he twice as likely to reoffend as the offender in category 2? And how much judicial discretion should there be to interpret these sorts of things? The grid lays it all out in a nice, clear, consistent way. And so we're just asking, whether this is in fact the optimal way, or whether the row should be expanded or contracted, and these sorts of questions. But I won't say any more about the grid because Rhys is now going to take you deep into it.
So I'm curious if we can vote. How many of you are familiar with the Minnesota grid? I know there's a lot of prosecutors and defense attorneys, and so it's something that you look at every day. You probably have it taped on a wall somewhere. How many people aren't that familiar with the grid? Okay, so some people not that familiar, and a lot of people didn't seem to vote, so I guess it's self-imposed disenfranchisement here. Well, I'll take a second, although I think there's a lot of familiarity with this grid. If you're not familiar with the grid, Minnesota is a sentencing guideline state. It's part of structured sentencing, which swept a lot of jurisdictions in the 70s and 80s, but not every jurisdiction. I come from South Carolina, if you can't tell by the way that I talk, which is unfortunate for me because research shows that a Southern accent people interpret as the person having 15 points lower IQ. A British accent gives you 15 points higher IQ, just self-perception. So the perceived IQ gap is tremendous up here today, to my detriment. So in South Carolina, in actually a majority of the states, there still are no guidelines. And so judges have tremendous discretion, often 0 to 15 years or 0 to 30 years to sentence a person. And in the 70s, that outraged a lot of people and policymakers, and the federal system and Minnesota and a number of other states, about 18 or 20, depending on how you count them, adopted sentencing guidelines. And the idea with sentencing guidelines is to give a lot more structure to judges and to prosecutors in the courtroom work group so that you don't have these wide ranges of 0 to 30 years. So if you're not familiar with the grid, the two axes that are probably self-apparent are that first, the Minnesota, the early commission scored all or ranked all of the severity level of all the offenses. So at the top of the grid on this severity level 11, the row 11, that's as bad as it gets. There's actually a 12 that's first-degree murder, which isn't even shown. But the top of the grid means it's really severe. The bottom of the grid means it's much less severe of a felony, and they're ranked, and that's fairly non-controversial, I think. And then the second axis that represents the columns of the grid is the criminal history score that we'll get into a lot today. And the numbers in the middle of the grid represent months. If it's a white shell, that's a month of imprisonment. The italicized numbers down there, I'll zoom in a little bit, is the range that the judge can sentence within without departing from the guidelines. In the top non-italicized number is just kind of the standard recommendation. Those gray cells at the bottom are lower severity, lower history individuals who were recommended for a non-prison sentence. And so the recommendation for the judge is that this person get probation or maybe some jail time, but not actually a prison sentence. Okay, so we're okay, I think, with the top to bottom, but let's talk a little bit about the left to right. And I think what we're inviting you to do today is to think about something, to dig in, and look under the cover of something that for a lot of us is just intuitive. You think, oh, criminal history, 6 points is more than 4 points, so yeah, this guy should get punished more. And we're going to ask some probing questions, I hope, about this. My job for now, though, is just to illustrate with a concrete example what we mean by the term criminal history enhancement, which we will use a lot. And you can see that there's two ways that criminal history, at least two ways that criminal history strongly affects sentencing. One of them is that for these people on rows 1 through 7, for the white cells out here in what we'll call zone 2, we'll get into this in a little bit later in the presentation, criminal history is essentially they're pushing themselves into prison because of their high criminal history score. If they had never committed an offense, they would be in the gray zone and wouldn't go to prison. So that's a dispositional issue, probation, jail versus prison, the disposition. There's also the durational issue of how much time you're going to get in prison on account of what you've already done in the past and already paid for in the past. So this is paying again for the past. And you can see for just the top row, for example, your criminal history can drive you from 306 months for a first offender up to 426 months for an offender with a criminal history score of 6 or more. All right, so how about an example? I'm going to use an example from row 8 of the Minnesota guidelines, which could be first-degree burglary or aggravated robbery. Are two common examples. Okay, imagine two people. These will be two guys. First guy with glasses, commits a level 8 offense, and he's never been convicted of anything before. He has a criminal history score of 0. And so the Minnesota guidelines recommend to this judge 48 months in prison, 4 years in prison for the guy with no prior record. Now imagine a guy who is, we like to do hypotheticals as professors, so hypothetical, he's exactly the same. Socioeconomic background, maybe that shouldn't even matter in sentencing. Race, age, gender, those should matter in sentencing, but even if they did, they're the same. Family situation, everything is the same about the second guy, except he has a criminal history score of 6. And so the criminal history enhancement in this case is going to be 5 years difference for the guy with the beard. And as a bearded person, I find that very disconcerting. Even the lawyers among us can do this math, right? What's the difference, or get close to it. We can take a third, and that's about what we do. But you can get pretty close to how much more punishment the guy with the beard is going to get versus the guy with the glasses. It's about twice, but a little bit more than that. 2.25 times as much punishment. He's paying again. that much more. And it turns out this is 9 years, right? This guy gets 9 years versus what this guy's getting for 4 years for the same penalty. It's just the past is what's bringing in this extra punishment, the enhancement. All right, so what goes into a score? And this is one of the things that we hope our project is highlighting for jurisdictions to take a look at, and just for practitioners to take a look at, not take for granted. I mean, if there's one thing for a takeaway today is not to take for granted that there's a number and that the number 6 is bigger than the number 4, but to look under the hood to see what's going on. So as many of you know, because you deal with it every day, but not everybody knows, jurisdictions differ on what goes into the criminal history score, but common elements are the number of prior felonies. Every jurisdiction includes some count of prior felonies. Minnesota and most jurisdictions differentiate to some degree on the weight a felony gets. Some Minnesota felonies get 2 points, and some get 1.5 points, and some get 1 point, and some get a half a point. And so there's some differentiation there. But states vary widely in how much they differentiate on the weight of the felony. And then we also, in Minnesota, add misdemeanors. So a couple of misdemeanors will get you one point. Most jurisdictions add misdemeanors to some degrees. A couple of states add every misdemeanor. Some only count serious, and so there's a lot of variation in the way that misdemeanors are counted, but you get points for misdemeanors. Juvenile adjudications. In Minnesota, we include points for juvenile adjudications, which maybe it gets some interest given what we've learned and what the kind of the direction the Supreme Court has been headed with Miller and Roper versus Simmons and the cognitive psychological research on brain development. Should we count juveniles or not? We'll talk about it a little bit later on. But we do. North Carolina is the only state that doesn't count them at all, and some states count only felony equivalent misdemeanors and felony equivalent juvenile adjudications, and some count felony and misdemeanors. And then finally, custody status violations. 8 or 9 of the guideline states automatically add a point for a custody status violation. And a handful of other guidelines jurisdictions, it can be an aggravating factor for the judge to consider. But those are all things that go in. I think one point, if I can kind of push in on it a little bit, is that the criminal history score does not necessarily represent the number of felonies a person has committed. It doesn't necessarily represent the nature of the criminal record, that it's violent or serious level offenses. It's a score, and a lot of things can go into that score. For a half or more jurisdictions, count those prior felonies forever. It doesn't matter if it was a year ago or 10 years ago or 30 years ago. In Minnesota, they count for a long time. And so there's a long, what we call the look-back limit. And so you capture a lot of things for a long time in this criminal history score. All right, well, before I get there, so a couple points, and then I'm going to turn it back over to Julian. So these are increases that are quite substantial. I mean, I think 9 years versus 4 years, you got to ask yourself, what are we getting for that extra 5 years for this guy? Now, the guy with the beard, he could get to 6+ because he's got 10 violent felonies and he's really a horrible person, and we're all happy that he's going to prison for a long time. But in Minnesota, he could also get to 6 points because he's got some misdemeanors. He had a juvenile adjudication. He's got a couple of lower level felonies, but nothing that's dangerous or even a person level felony. He's got a drug offense. He's got a low level theft offense, and maybe another along those lines. He was on probation for a long time and revoked his probation towards the end of it, and that all of a sudden he's up at 6 points. A guy with a murder conviction, but nothing else, is sitting at 2 points. And so there can be a real disconnect. And the point is, there's some people in the high criminal history category who really are the kind of people you think of with high criminal history career offenders. But there are a lot of people who could get up there quite quickly, move along the grid without egregious offending patterns. And what are we doing to this guy? A substantial increase in his punishment. So 2.25 for this particular row on Minnesota. In the source book, I think it's chapter 2, we break down a number of jurisdictions and we average out the whole grid. So the way that we count it for Minnesota, the average multiplier at the extremes is almost 4.7. So the high history offender is getting punished or the recommendation is 4.7 times greater than the no history offender. In some jurisdictions, it can be much, much more robust than that. In this example from Washington State, 30 times greater because of what the person did in the past, not because of what they did that they're being sentenced for today. So as Julian pointed out to me as we were talking through this yesterday, 97% of this guy's punishment is for something that he's already been found convicted of, found guilty of, convicted of, and paid his debt to society, supposedly, but he's paying again over and over with this criminal history enhancement. On average, for the Washington State grid, which is kind of a high average, is about 10 times. But still, I mean, you're talking 1,000% increase in the punishment because of something that a person has already paid for, already paid their debt to society. In some places, maybe it's 500% or 200% on particular rows. But Julian's going to walk us through why we have these premiums. How can we justify punishing a person that much more for something that they did in the past and that they've already paid for? There's some answers, but there's some issues with some of the answers. So, Julian.
Me again, and in case you didn't know from the accent, I'm from Oxford. Justifications. So there are two, aren't there? And they're pretty obvious, and they are found in the guidelines manuals. But let's talk about them a little bit further. The risk argument is simply that repeat offenders are more likely to reoffend, and therefore we need to punish them more in order to prevent further offending. So that's a pretty intuitive and straightforward, but I think we need to unpack it a little bit more. We think that there are three things we really need to do to justify prior record enhancements on a risk-based analysis. So the first thing you have to obviously demonstrate is that prior convictions are indeed predictive or probative of future offending. Is it the case that repeat offenders are more likely to reoffend than first offenders? And it is, and there's a ton of data from Minnesota and all sorts of other states and jurisdictions showing that recidivism rates escalate in response to the number of prior convictions. It's not a perfect or it's not like the relationship between height and weight and so on, but it's a pretty strong relationship. So that's fine. We've established that. But the second thing we need to do, I think, is demonstrate that the intervention that we're triggering or activating will do something about the higher risk, which we've demonstrated at step 1. Because if the intervention is not reducing risk and reducing the likelihood of further offending by that offender or others, then it sort of calls the whole enterprise into question. So that's the second sort of assumption or prerequisite, but there's also a third. So if we demonstrate that people with prior records are more likely to reoffend, and we demonstrate that more punishment does prevent more crime, we also need to establish, I think, that this intervention is cost-effective. It's not just effective, but it's cost-effective, and more cost-effective than other interventions. And as we'll show, and as I'm sure you're aware, the longer you put people in prison, and obviously the more people you put in prison, the more expensive it becomes. And there are other adverse consequences, collateral consequences, we might call them, within the sentencing system of a strong prior record enhancement. And we need to know, even if the prior record enhancement is effective, that it's not costing us too much. And then we'll get into racial disproportionality and various other costs. So risk needs to be unfolded in those respects. And we also need to calibrate the degree of the enhancement imposed on the repeat offender to the actual risk of reoffending. And sometimes, in many cases actually, the current offense is not necessarily a good predictor of future offending. So there have been a number of studies in different states showing that the likelihood of, let's say, a violent crime, given that the offender is currently convicted of a violent crime, is no higher than the likelihood of a property crime. In fact, for most offenders, the likelihood of a property crime is much higher in terms of reoffending than whatever they've been convicted of. So risk is a bit more complicated, and of course there are many other factors which predict why people reoffend, having to do with substance abuse, various social problems and so on. So it's not all about prior convictions. Prior convictions are, in a sense, a proxy for risk. We're sort of ascribing higher risk to repeat offenders, and in many cases, or most cases, that may be true, but in some cases it may not be true, in which case we're punishing on a rationale which has yet to be fully established. Now, the second argument or justification for prior record enhancements seems even more obvious. Well, they deserve more punishment. Again, that's an assertion. I think you need to unpack it. And if we're talking about retribution or the just desert sentencing philosophy, it's not clear at all that repeat offenders deserve more on an enhanced culpability model. And so you might say, well, do they deserve more punishment or not? And if you turn to the legal philosophers or penal theorists working in the area of just deserts, they won't necessarily agree that repeat offenders deserve more punishment for their prior offending. George Fletcher, the great American jurist, great legal scholar, said that the prior convictions have no role to play at sentencing. Why? A retributivist account would say, because prior offending doesn't make the offense more serious. You don't feel any worse if you've been knocked on the head when you learn that the offender had prior convictions. You don't feel any better if you hear he's a first offender. So prior convictions don't affect the seriousness of the current crime. And Fletcher's view on culpability was, well, it's not relevant to culpability for this offense. It may mean that this individual is the kind of character who's antisocial and he's got problems and so on and so forth, but his culpability for the current crime is unaffected by the fact that he has prior criminal adjudications. Fletcher had quite a compelling analogy, and he said, well, you could imagine culpability as being an index running up to 100. And so if you commit the crime and you've got no excuse, no mitigation, nothing, no claim for diminished culpability, you get a score of 100. But if you then start putting on the table some appeal for diminished culpability, well, I was provoked by the victim. Okay, we give you a culpability score of 80. I was subject to social adversity, lost my job, I was discriminated against, and I sort of started to drink, and that's where the crime came from. So we'll consider you to be less culpable for that reason and give you a score of 70. So diminished culpability at sentencing on Fletcher's model can go down, but Fletcher's point was you can't be hyper-culpable. You can't go above 100. And that sort of stopped the field for that was in 1978, and stopped the field for a long time. Andrew von Hirsch, another penal theorist, just desert theorist, argues that prior convictions, or the absence of prior convictions, should mitigate. So there's a first offender mitigation. But once that's been exhausted, you wouldn't aggravate again because it's unrelated to the seriousness of the crime. So the simple point I think to make there is that we can assert that repeat offenders are more culpable, and therefore that's a foundation for punishing them to a greater degree. But I don't think we can just assume it's the case in all cases, and it's a bit more complicated, as the legal philosophers will demonstrate. I think there's one thing that, if we're trying to establish whether these systems are founded on risk or retribution or both or some combination of both, I think there's one thing that we can agree on, or they do agree on, and I'll come back to this in the sort of suggestions for reform, and that is that older priors should probably count less than recent priors. So an offender has a 14-year-old felony, and the retributivists would say if it is relevant to culpability, and as they say, they're not convinced it is, but the offender who's gone 14 years without reoffending, even if he's now has reoffended, he's probably less blameworthy for that crime because it happened 14 years ago rather than last year. And on a risk-based analysis, the risk justification surely would say, well, if the prior conviction was 14 years ago, it can't carry the same weight in terms of risk of reoffending as if it happened last year. So there are some points of congruence in some ways in which the two justifications will part company. But let's turn to the impacts of these enhancements, and that's back to Rhys.
Okay, so maybe there are benefits from criminal history enhancements. Maybe there are benefits in our ability to predict risk, and in the moral position of just deserts, retribution, and there's some questions about that. But what are the costs? And in particular, a couple of negative impacts that we've been looking at in the course of this project. Most of this work started with Professor Fraze's work. If you're interested in this and you've not read his volume 38, Crime and Justice, on persistent disproportionality in Minnesota, you'll clearly see the genesis of this work. We'll talk about 5. Some of them I'll just mention briefly, and some of them I'll give you a couple of data points on. The first is, to the extent that you're concerned with offense-based proportionality, criminal history enhancements confound offense-based proportionality. A high history level 2 offender will get more punishment than a low history level 3, 4, 5, 6, 7 offender on the Minnesota grid. And if you don't care about offense proportionality, then maybe you say that's the whole point of criminal history scores. But a lot of people do care about offense proportionality, and so it's a confounder. It also contributes to the aging, graying prison population in the United States or in any given state, despite the fact, I mean, are you familiar with the age crime curve, a very robust finding in criminology that offending rates peak in the late teens and then begin to drop off? Even for the worst people. I mean, the really, really persistent offenders will continue to offend into the 30s and 40s, but it becomes an increasingly small percentage of people who do that. And in the 20s and 30s and 40s, even bad offenders desist from offending. And yet the criminal history scores, because a person accumulates this larger criminal history over the course of their life and their criminal career, we're punishing them more than we've ever punished them. The farther along in their life they get, and it kind of creates this cross purpose with what we know about desistance from crime, and does contribute to, especially to the extent, for point number 3, that these are largely low-level, at least non-violent offenders, non-person offenders. And so if you hold the view that prison is kind of a last resort, we have to have prisons, and we want to reserve our prison bed space for people that we're afraid of, people who really pose a threat to doing serious bodily injury to other individuals in society. And yet with criminal history enhancements, we're punishing people and putting them in prison and for longer and longer periods of time who are committing lots and lots of drug, property, and other non-person kinds of offenses, and so that could create some conflict. Overall, these together contribute to the size and expense of prisons, which people are more and more interested in discussing these days, it seems. And finally, I'll have a couple of slides on the racial impact of prior record, because from what we're able to tell in the United States right now, it's essentially a universal finding that African Americans have more extensive criminal histories than white offenders, and therefore it's an indirect impact on racial disparities when you have criminal history enhancements. All right, so just highlight a couple of these with some data points. To get there, we'll revisit the grid, if you will, in a simplified form. And just think of these as 3 zones. The top zone, zone number 1, everybody in this zone, regardless of their criminal history, is recommended for a prison sentence. So we can think of these as high-severity offenders, and they're all recommended for prison, and we can treat them a particular way in our mind. Zone 2, these are the people that I mentioned before who are pushed into prison because of their own criminal history scores and their prior record. This is our focus. We're going to look in depth at these folks. And then zone 3, those are the people who are low severity, low history offenders, and who also fortunately make up most offenders in most jurisdictions. Okay, so a focus on zone 2. Well, for starters, zone 2 offenders, there comparatively aren't that many of them. They make up about 19%. This is based on 2014 Minnesota data. About 19% of the sentences were for zone 2 offenders. But for the prison sentences, and you can see this is for the main grid only, not the sex grid, but for the main grid, about 25% of individuals are recommended for prison, and 55% of the prison recommendations come not from this zone 1, the really serious offenders, but from zone 2, high criminal history offenders. I don't have the percentages up there, but I think it's interesting to note that the conversion rate, if you will, from total sentences in zone 1 to people who actually get prison is actually higher for zone 2 than it is zone 1. About 63% of people in zone 1 who are recommended for a prison sentence actually get a prison sentence, and about 73% of people in zone 2 get a prison sentence who are recommended for a prison sentence. That may change with the new drug grid, because a lot of these zone 1 folks were category 8 or 9, and the downward disposition were the high rates of dispositional departures for drug crimes. So that conversion could change. But anyway, the point is this is making up a large part of our bed admissions in a given year. Just a couple of points along those lines. 55%, as I just said. Of course, high severity offenses have longer prison sentences that are associated with them, and so they account for longer prison bed durations. But still, 37% of prison bed years imposed in Minnesota come from this zone 2. And finally, to the point about prison bed priorities, of these zone 2 individuals, about 70% of them are non-person offenders. So they're, today at least, being sentenced for drug crimes, for property crimes, or for other non-person offenses. Well, just a little bit on the race issue, and Professor Frase's other work goes into this in depth. And also in the source book, which there are copies of it out there, is chapter 12, I think, right, Richard, of the source book, is a chapter devoted to race, and you can see a lot of detail about how we come up with this. So we'll ask this question, for this slide will illustrate the black-white disparity in recommended prison rates in Minnesota, and then I'll show you a couple of other jurisdictions. And so if you were to just think, before I show you any data, if blacks and whites, African Americans and white offenders are recommended to prison at different rates in Minnesota, why? Would it be because of things like mandatory minimums? Would it be because African Americans are charged and convicted or plead guilty to higher severity offenses, or because of our zone 2? And what we've found is that 8% of the disparity comes from these low severity, and these are actually kind of mandatory minimums and special rules, where most people in this zone aren't recommended for prison, but sometimes special rules apply, and you can have a mandatory minimum rule that applies. So a little bit of it is there. About a third of it comes from differential rates in high severity, but the majority, 56% of the black-white disparity in recommended prison rates in Minnesota comes from this zone 2. And this doesn't appear to be a unique phenomenon to Minnesota. We've replicated in several other guidelines jurisdictions, and this is a chart that comes from the source book. And you can see between 40 and 60% of the black-white disparity in recommended prison rates in each of these 4 jurisdictions comes from this Zone 2. So at the end of the day, we have to look closely at those justifications, but we also need to keep in mind the costs that are imposed, figure out what we're getting in terms of benefits, and have a sober look at the costs that we're incurring because of not what a person has done and is being held accountable for today for this offense, but the things that we're having a person pay again for because of what they've done in the past, paid for in the past, and are now being asked to pay for it again. Okay, Julian's going to wrap us up with some conclusion and some recommendations to stimulate our thoughts.
Thanks. Yeah, so we're skating pretty quickly over a lot of issues here. Hopefully the ice is not that thin under our skates, but we're going to have a Q&A at the end. So if there's something you think, well, that can't be right, or what's your evidence for that, feel free to intervene. So just to summarize the key project findings so far, the first thing is, as we've seen, there's great variation in scoring formulas and magnitudes. As we noted, one state doesn't count juvenile prior convictions and the others do, and some underweight and some don't. So there's got to be a best practice. I mean, who's got the right answer? So this is, as I say, the opportunity to learn from each other. That's one of our primary findings. The second, and it's following on Rhys's recent data, the most recent slides, are you comfortable with the impact that this practice has upon racial disproportionality in prison? You may say, well, prior convictions make the offender riskier and more blameworthy and let the chips fall where they may, but it's an important consideration. Look-back limits. Some systems don't have any look-back limits. So a 55-year-old offender just convicted of an offense, and the system looks way back into his past or her past. Is that appropriate? Should these things hang around forever? And if you're going to have look-back limits, where should they be? But we found, looking at the states, that look-back limits are quite rare and pretty generously broad as well. And I think the fourth point we just make, a key finding, is that there really hasn't been sufficient evaluation or re-evaluation of criminal history policies. The grid in Minnesota was created and almost 40 years ago. Other grids and other guideline schemes also created over the years. Maybe it's time to think a little bit more carefully about what these enhancements are doing. Now, in making these proposals, we should bear in mind the kind of caseload we're talking about. So here's the Minnesota data. Only 10% of the offenders are in that most serious criminal history category. So we're not talking about those. Then you've got the first offenders, 1/3. Interesting empirical finding, by the way, in the early years of the Minnesota guidelines, about 2/3 of offenders were in the first column. Now it's down to 1/3. But we're sort of talking in terms of any reform proposals about the middle group, almost 60% of the caseload. People with pretty modest criminal histories, and as we've seen, or as you probably know, it's pretty easy to get into Category 3. You need 3 criminal history points, and you can get that in various ways. So just to be clear about the target population of any potential reforms. So we're putting some considerations on the table for discussion. I'd be interested to hear your views. And one sort of suggestion we might have is limit the magnitude of impact. So does it really make sense to have a sentence, 97% of which reflects the prior conviction, only 3% is accounted for by the crime he's committed? If I may quote my eminent fellow Brit, Boris Johnson, he'd say that's bonkers. A retributive theorist would object to that. So how do you think about it? So you could have a cap, and a cap could be something like the sentence can double. That still gives you quite a whack. If the first offender gets 18 months, you can go up to 36 months for the recidivist offender, but not beyond. Once you go beyond, then the offense carries less weight than the prior offense. So that's one possibility. Limit the impact of older offenses. This seems to be a pretty compelling argument. It's my personal view. I'm sure what my colleagues will say. But we talk about the decay factor in the guidelines, but of course they don't decay. Minerals decay or isotopes decay. I was never very good at science. Isotopes, I guess. They decay over time. But as long as the prior conviction is within the look-back limit, 10, 15, it carries the same weight, generally speaking. So maybe it should decay over time. So maybe you get, X points, 3 points, let's say, or depending on the system, for a prior felony. After 5 years, the prior felony is worth less in aggravation. That seems pretty uncontroversial to me, at least. Well, what about a look-back limit of, say, 10 years? Some states run a 10-year policy. Exclude adult prior convictions older than 10 years. You might want to have some exceptions. The very serious crimes would stay alive for a longer period. But at some point, I think the argument would be that you need to sort of close the door on the past. Well, the offender's going to be paying for the past repeatedly. It's important to bear in mind also, I think, some people find this, don't think of this immediately, but there's a snowball effect here. So you commit a crime, you reoffend. On the second sentencing hearing, you'll pay an extra price for the first offense. If you reoffend again, the third conviction carries a premium based on the second and the first, and so on. So on the seventh sentencing hearing, that first prior conviction has repeatedly re-emerged. And if you were to add it all up, that's a lot of repeated punishment for the same criminal act. So we think there's certainly scope to talk about limiting the weight of older priors or excluding older priors once a particular period has been reached. Now, there's a sort of a human psychology argument here too. It gives the offender, or the ex-offender, I should say, an incentive. If you go for 10 years without reoffending, if you desist, that prior conviction will be expunged. So that's something that the offender can be aware of and actively work towards. But if you've got a prior conviction and you know it's never going to go away, does that make sense? Limit juvenile priors is another, I think, suggestion which is worth exploring. Some systems limit prior juvenile adjudications by underweighting them. Some cap them. Some discard them or discount them once the offender reaches a certain age. So there are various options here. You could disregard all prior convictions, juvenile convictions, when the offender turns an adult, again, unless it's a particularly serious offense. You could keep them alive for a limited period of time, 18 to 23. You could downweight them. But it's certainly worth thinking about because there are reasons related to human development to suggest that, when you become an adult, you change, and possibly you should be given the opportunity to put aside your previous juvenile criminal indiscretions, as it were. Now, you may be thinking, many people are thinking, well, you may be thinking there's 10 minutes remaining. And you're right, and I can confirm that. Well, wait a minute, the public's not going to support this. Not counting priors after 10 years? What if it's a serious robbery? He's just turned 19 and you want to disregard those juvenile convictions? So we explored this a little bit in a national survey where we asked them questions about limiting, having a look-back limit, and also restricting the use of juvenile convictions. So we put a question to the public, the US public. Imagine your state, I'll read you the exact question in case you think it's sort of leading. Imagine your state is considering passing a new law related to criminal sentencing. Under the new law, judges would not be allowed to count an offender's prior criminal convictions against him if the convictions were committed while the offender was a juvenile. Which of the following best describes your position? I would support the proposal that offences committed as a juvenile should no longer count against the adult offender. I would not support the proposal. I believe that judges should be allowed to increase punishment for offenders who committed crimes as juveniles. And we asked a similar question about look-back limits. I won't repeat that. It's just carried the same. Well, I'll give you the exact question. Imagine your state is considering passing a new separate law related to criminal sentencing. Under this new law, judges would not be allowed to count an offender's prior criminal conviction if the crime was committed long ago. Those in favor of this policy argue that society shouldn't count past crime against offender forever. Those against this policy stress that even old crimes continue to be relevant for determining punishment for a new offense. So we're putting arguments on both sides, trying to be balanced. Which of the following best describes your position? I would be in favor of limiting the offences used to increase punishment to more recent convictions, or I would be in favor of allowing all offences, new and old, to count against an offender. And here's what we found on this national public survey conducted this summer. 69% were in favor of restricting old priors. There was increasing disregard for aging priors in sentencing vignettes. We asked people to sentence offenders with a prior conviction of a different age. And as the prior conviction got older, people were far less punitive. And I think that's pretty intuitive and pretty reasonable because, of course, the newer prior conviction seems more relevant to the current charge. And approximately 3/4 were in favor of restricting the use of juvenile priors. Now, we're not arguing, well, that's what the public thinks, so we should implement that policy, but it does give you some sense of where the public stand on these issues. And the last sort of suggestion we'll make is a bit more speculative, and may not appeal to people who are sort of guideline grid fundamentalists, but the idea is to allow some judicial discretion in interpreting the criminal record. So, for example, a court could be empowered to increase or decrease the history score or underweight the history score if it seemed to indicate the offender was more blameworthy or a higher risk than it is in fact the case. So there could be departures on this grounds from the guidelines as well. And I think it's important, this is my personal view here, because, you know, in my country, a common plea in mitigation by the advocate at a sentencing hearing is to contextualize the offense. My client's got criminal history score of 4, but let's unpack those points. You know, and one of the felonies was 8 years ago, and then, you know, he had a problem with drugs and blah, blah, blah. So there's a story, there's an account, and we shouldn't be treating two offenders, both with the same criminal history score, in the same general way if there are reasons to suppose that the criminal history score doesn't accurately calibrate in both contexts. So, just thinking about allowing a little bit more judicial discretion in terms of the interpretation of the impact of the criminal history score on sentence outcome. Now, that's all we've got to say for the present. We're going to open it up. Rhys, can you come back up here? We've got a few minutes before we take a coffee break, but we're going to open up to commentary, questions from the floor.
Okay. Okay, I have a question. One of the things I'm kind of surprised you didn't mention is the use, at least here in Minnesota, of using concurrent sentences, felonies that you've been sentenced on concurrently to increase your criminal history for sentences that are being imposed 10 minutes later. And I'm just curious if that practice is how widespread that is across the United States in guidelines jurisdictions.
Yeah, I was just going to say, I think we'll call in some friends here and invite Kelly and Richard, who are both deeply involved in this project, to answer questions. So this is Hernandizing in Minnesota, and Richard's probably in a good position to answer.
I think you should come here. Yeah. Hang on there. We're bringing in the heavy hitters.
Yeah, we look. It's discussed in the source book that summarizes our comprehensive survey of these formulas around the country, and I think it's in chapter 10 of the source book. So the short answer is there's only one other state, Washington State, that does what we do in terms of so-called Hernandez, where as you sentence somebody for multiple counts, they move across the grid from count to count. So with each new count, we add the previous counts to the criminal history. So in one day, in one hearing, a person could move all the way across the grid. There's only one other jurisdiction that does that, Washington State. In fact, their rules are slightly more severe than ours in this respect. However, there are 5 jurisdictions, I believe, in which multiple current offenses increase the recommended severity in the current sentencing through a different kind of formula. So, for example, a lot of systems have a point system, and your total points determines the nature and severity of your sentence. So they don't use a grid. It's all worksheets and points. But multiple current offenses add to your points. So of the 18 jurisdictions we surveyed in the source book, these are jurisdictions that have something like a criminal history score that you could identify and analyze. Of those 18, 7 count multiple current offenses as aggravating the recommended current crime. Before you even get to issues of consecutive sentencing, just concurrent sentencing, but more severe recommended concurrent sentencing for these multiple counts because of the number of separate counts. So we're not unique in that broader sense, but we're kind of unique, except for Washington State, in actually putting it into the criminal history score. So I hope that answers the question.
Thank you. Stick around. We may need you again.
In your example of first-time offenders and then those with 6 points, I was just wondering if you could talk more, because those that have just kind of the points seem to be masking variation. You know, like if you could kind of talk more about that, like so if somebody both has the same number of points, because of the trajectory that it took them to get there is so different, it's sort of the points itself is masking that variation, and it's appearing as though they're on equal footing as well, not just the different, when in fact it seems like they're also on unequal footing, just as in the extreme case, as you shared, the first-time offender and those with like 6 points hypothetically or whatever. So I was just curious, especially with bringing it back to your point about contextualizing each case by the courts. I was wondering if you could kind of discuss that a little bit more.
Yeah, I think it's a very interesting question you've raised. I've got a lot to say to it. I'll say something, and maybe Rhys will want to too. So I put the grid back up. Yes, and it's assigning points for criminal history scores creates this Procrustean effect. You get offenders with very different criminal histories in terms of the trajectory, as you put it, or the components, and they both have the same score, but they may be very different. And I think that's one of the problems of having a scheme like this. Of course, there are benefits to a scheme like this because you've got simplicity and clarity, consistency of application. And if you left it to a judge, as is the case in these other jurisdictions like England and Wales, a judge looks at the record. Okay, well, you've got 2 priors. It comes up with a decision as to how much to increase the sentence. And then, of course, you don't have consistency. But there are costs and benefits of both. And the cost here is that 2 offenders with very different risk and retribution profiles, if I can put it that way, may end up in the same box. Now, of course, the commission might say, well, let's have a look at a box. Let's look at level 8, criminal history score 3. 78 is the presumptive sentence. There's a range of 67 to 93. So presumably the court is deciding within that recidivist range, within the box, that this is a less serious criminal history, even though it's got the same score. But I don't know, and this is an interesting research question, how much that variation is used and on what basis it's used. So you've touched on, I think, a very interesting point. But Rhys, do you have any?
I would only say thank you for the question, and I would invite you all, especially you who deal with the grid, to ask yourself a similar question. How much faith do you put in those numbers? Because the Minnesota system in particular has a very precisely calibrated, on the surface of it, 0, 1, 2. I mean, we're counting individual points, and you move one unit across for each point. And again, we've encouraged you today to look past just the numbers, as Stephen's question kind of suggested. A person with a 2 and a person with a 2 may not be the same. And I'll leave you with this question: if you were going to have to host a person, and you could one person that you were going to host overnight in your house, I told you had a criminal history score of 3, and the other had a criminal history score of 2, would you feel comfortable in going, oh, well, definitely give me the 2? Or would you like to know some more information before we thrust that on you? What about 2 and 4? And my point is that a murder gets you 2, and a lot of small things can get you 3 or 4, and I think that was part of Stephen's point. And so, there are other ways that you could calibrate the way that you score the points, and I think it's a good question.
Regarding your proposal to limit the look-back period to 10 years for the effects of prior convictions, would you exclude from that 10-year period the time that the offender is incarcerated for that prior offense? Or would you allow, say, if you're serving a 15-year sentence, that 10-year period would lapse during the time of incarceration?
Yeah.
It depends on which one of us you ask. But I'll let
Yeah, this came up at a professional meeting in the summer. So the prior conviction is 15 years old, and he's been in custody for 14 of those years. That's the sort of scenario you have it just to imagine. Well, my feeling is, why wouldn't you take that time into account? Because it was 14 years ago, and whether he's been in prison or not, it seems to me irrelevant. 14 years ago, he committed this crime, and I therefore feel that can claim that he's a different person after 14 years. And if he's not a different person after 14 years in prison, I think that's your problem, not his, because prison's supposed to have reduced that risk. So it's like a Joseph Heller catch-22. You're in prison, we're going to make you, we're going to change you, and after 14 years in prison, the prior conviction counts against you because you haven't changed. Well, yeah. So I think it should be taken into account. And if the individual is in prison for 14 years on the retribution argument, I would say, well, yeah, it's 14 years ago. So to me, it's immaterial as to whether he's was in prison for this period or most of this period or not. Rhys erroneously thinks otherwise. But the case
Thanks so much. I think there are two ways of looking at it, and really two justifications for why you would impose a look back. And one of them is, I think it's valid for Julian's, although I would count it longer instead of 10 years. Maybe it's a little bit longer. But the fact that people do change over time. So even if you've been in prison for the entire time, there's a fair inference that a lot of people will be different after 15 years, even if they've been in prison. And I think that's what Julian locks onto. I think there's also another perspective, which is you need time at risk in the community to prove to us who you are again. And so if you're under that perspective, I would argue that you need 10 years at risk in community. But it's also different from the current Minnesota rule, which I think is significant enough to point out. Minnesota has a 15-year look back, but the clock doesn't start running when you're on supervised release, or if you're given a probationary sentence of 15 years, which is possible in Minnesota, and you serve your 15-year probation, then you've expired your sentence, and then your 15-year clock starts. So you've got a 30-year, this thing is on paper for you, which I think takes it too far. You don't give credit at all for a person being at risk. And so I think that's the worst of the three options, and I'll let you decide whether Julian or I have convinced you more on the other.
All of your recommendations would reduce racial disparity, but I think that your work also makes a good lens for looking at law enforcement practices. We have 5 major studies that show a very high rate of racial profiling in Minnesota, and that's how people get these criminal histories. If you stop a person on the street, every couple of days they're going to get a higher criminal history pretty quick compared to somebody like me that doesn't get stopped. What do you think about that?
Yeah, it's a very important point. I mean, the model assumes, okay, we've got these 2 offenders, one's got 6 priors, one has 1. We sort of assume that they had an equal probability of the state detecting criminal conduct and therefore acquiring a prior. So that's not a sentencing problem per se, but it's a problem that the sentencing process should probably consider. Yeah.
Can I come up?
Yeah, please.
Great. Hi, I'm Susan. I used to work in the Stillwater prison in the education department. And I worked with the lifers, and I worked with people who were trying to figure out what can really be done on serving the sentence to make it safer for society when people reenter. And what I'm hearing is that right now we're putting people in prison basically to punish them as a deterrent, to safeguard society, or for rehabilitation. And I'm not sure how much we focus on that rehabilitation element. When you've talked about the sentencing, like you have your offense, and then you have the enhancements that you're talking about. Okay, so we have the offense, we have the enhancement, which is based on a statistical, is this person going to harm us if he comes back out? What we care about is the actuality. Would it be safe to let him back out? So one of the things we came up with in the prison was talking about something sort of like your 4-year school plan, where you have to take English, you have to take math, you have to take history. So taking the time a person is supposed to serve, giving them like a plan where you have to do this for a year, where you have part of it is your skills, your job and education. You have to meet that criteria that first year. You also have to meet some personal development, your programming, the nonviolence programs, the anti-drug programs, the understanding why you're a sexual offender programs. You also have to participate in social activities. There's sports, there's clubs that you can join. With that, things where you maybe have to be in some leadership positions or work towards that. Also the reentry skills, because these people are coming out without knowing how to get a job, what finances are, how to do anything. So to gain some level of reentry skills every year. So you finish your first year of it, then you go to the next level. And kind of a 4-year phase, you don't graduate until you've reached a certain percentage of this or whatever. So this is a model where maybe the people will be actually ready to reenter, have respect for themselves, start respecting other people. If you can take this model and then go back to where you had their actual offense in the sentence, maybe it's a model that could reduce that actual sentence by half. So if they had this huge sentence because of the enhancement, but the actual crime was a 5-year crime, no matter what their enhancement is, they could get down to 2.5 years if they're showing all this positive programming.
Thank you very much for that intervention. I'll just comment on that in the sense that, you know, this is a one-way street, the enhancement. It's just piling on punishment, and the offender doesn't really get a chance to respond. So, you know, one possibility is to say, well, your criminal history score is 6. Now, what have you or what does your attorney have to say about any efforts you've made to desist over the last 3 or 4 years? And again, in my country, there will be arguments put on the table. Well, my client has, addressed his drug abuse, and he's now working steadily, and yes, he's back before the court, but there are attempts at desistance which should be recognized by the court and which might wash out some of the enhancement which is imposed presumptively to reflect the prior convictions.
I have a question here. Over here. Hello. Hi.
Thank you. It must be these lights.
Rhys, when you introduced the grid, you had mentioned that the severity level, that vertical axis, isn't relative agreement from a maybe societal standpoint. And I just wanted to maybe have you comment a little bit on the whole felony DWI, because those of us who work in corrections have seen the impact that has had, and it's been huge in Minnesota. And so the fact that it's placed where it is, relative to where it could be, certainly higher or lower, has had a tremendous impact on our prison population in Minnesota.
Okay, so fair point. I think I'm willing to take a step back on my statement. I mean, there can be issues in any particular system with the severity ranking, and I think you've seen it in the last year in Minnesota with the drug re-rankings, because there was apparently so much disagreement with the guidelines on drug offenses, and the dispositional departures were so strong. So the general point that I meant to make was that there's research by Paul Robinson and other people, and there's general agreement on rank orderings of offenses, and that doesn't mean there's perfect agreement. And there may be sentences, particular crimes in particular places that are not quite right, and there's some tension, and maybe they get readjusted, or maybe they never really do. And so maybe DWI is an aberration to that general rule in Minnesota. I think the point, though, is just generally that we could mostly agree on the rank order, and I think there's a little less clarity on the justifications for the history. But thanks for the question. Yep.
I think it's interesting, given the title being "Paying for the Past: Consequences of Criminal Convictions." It just makes me think about not just only his, how individuals' past with their criminal record affects them, but historically the past, how that affects specifically people of color, African Americans, to be more specific. If you just think about how Angola, there was a slave plantation in Angola that was then within like 100 years turned into a prison where now 90% of the inmates or people in prison are black. So just leaving out with that, and also you mentioned culpability. Instead of, I know this was a while ago in the 80s, but by saying like, oh, okay, you have some hard times, we're gonna be more lax on you. But what is that doing for society? Because clearly these individuals are not just constantly going back to prison because they want to. They don't have much of a choice. You get out of jail, you can't find housing, you can't get employment. You can't do so many more things. You can't vote. You don't even have a say what goes on in the society that you live in. So I was just wondering, how do we expect people with past convictions, as Julian brought up, once you're in jail now, you got out, you did your time, but then what did prison do for you? How are you supposed to be better? And yes, it is very true that people change over time, no matter if you are in prison or if you are out. But your environment definitely makes a big, has a big. It affects how you change, whether that's positive or negatively. So I'm just wondering, how do we expect people with passive, convictions who have been in prison to just change for the better? When they do get out, then they either have to go back to the old ways that they had because they can't do anything with new resources, with getting new jobs and such. So what are we doing?
Thank you for that. I'll just add on my part, you're perfectly correct. People come out of prison and they don't have the tools to stay out of prison. And so this is a broader question, however, about the effect of imprisonment and the costs of a term of custody, which last and last. But we'll be coming to that later in the day, to these broader issues. We're almost out of time. We take one more question or comment, if that's possible. Or are there no more comments or questions?
At the risk of asking again kind of too broad a question, I mean, you've made a lot of, there's a lot of ideas here about reducing the role of these criminal history enhancements, but do you have a kind of a preferred framework for what to replace it with? Is it just flattening out the grid as we move from the left to the right? Is it real offense sentencing like they use in the federal system? Is it indeterminate sentencing? I mean, is there something that you prefer when you're thinking of this, of what to replace it with, if anything?
Yeah, so I'm speaking for myself, but the Robina project's not about, here's a new model, this is the way you need to get rid of that grid. No, we have a much more modest project at the present, which is to understand how it works and see if the grid-based schemes and the way the criminal history is calculated can be better calibrated to do what they're supposed to do. We're certainly not advocating a return to indeterminate sentencing. The only sort of increase in judicial discretion proposal that we're at least asking whether it makes sense is on this judicial interpretation of the prior record score. But I'm going to ask Richard to respond to this as well.
Yeah, I'm not sure I have anything to add to what Julian said, but because we are mostly about getting states with guidelines, especially because that's the focus of the criminal history project, to be clear on what their goals are, generally in sentencing, and particularly what they view as the primary justification for criminal history enhancements. Because you can't decide what you want to do until you specifically until you know what your general goals are. So that's each jurisdiction has to decide that, and it has implications. We'll talk some more about that, I hope, in the panel after this for how you design the score. I think at a minimum, we're trying to strike a balance here between a structured sentence that gives all judges a common starting point rather than 0 to 15 years. That's lawless. All judges should have a common starting point, a common set of procedures and standards for deviating from that starting point. And all we're saying is that criminal history, unlike offense, where judges are always asked to mitigate or aggravate the sentence based on whether there are case-specific facts that make the crime more serious or less serious, but when it comes to criminal history, it's just a formula. And almost no jurisdiction gives judges a power to, at least in exceptional cases, depart from that criminal history formula. And that just seems wrong. So I think, that's the reason for this, allow judges to make some adjustments. And we have differences among us into, how broad a discretion to allow on that. But beyond that, every jurisdiction is going to have to decide what their goals are and how that implicates their formula. And their goals consider underlying values, in particular social equality, racial justice.
Well, it just remains for me to thank you all for participating and for listening to us. Your reward now is a coffee break.